So hello, everyone. We'll get going. So thank you for joining us today for this presentation on the new opportunities for business research resulting from two recent reforms to Canadian privacy laws. So in previous conferences given by the BLG team, we've had the opportunity to present the broad outlines of these two important reforms. So you have Bill 64 in Quebec, and you have Bill C11 at the federal level. So today we'll focus more specifically on the issues affecting research and development within companies. I'm sorry, okay, here we go. So we propose to begin this presentation with a brief review of the history of the two bills since their introduction, as well as a reminder of certain key concepts in the area of data protection. So next, I'll begin by addressing the relevant changes contained in Bill C11 with respect to research, and then I will turn it over to my colleague Andy, who will cover the changes introduced by Bill 64. In conclusion, Andy will give you an update on the status of each bill as of today, and we will then conclude with a question and answer period. Some of you sent us questions at the time that you registered, so we've taken good notes and we will be addressing many of these questions towards the end. So Bill, quickly, maybe a quick introduction. So Bill 64 was introduced in June 2020 by Sonia Labelle, who was then the Minister of Justice. This bill reforms both the Act respecting access to documents held by public bodies and the protection of personal information, so the public sector law, as well as the private sector law. Specific consultations were held in 2020, during which dozens of stakeholders shared their views on the bill. And if you're interested, most of these brief or the documents, the submissions made are available on their website. Most of these documents are in French, but they're publicly available. The BLG Montreal team filed a submission in which we provided recommendations. I also testified. If you would like to get a copy of our submission, just email us, email me or Andy, and we'll send you a copy of our brief if you're interested. In January 2021, Eric Kerr was appointed minister responsible for the bill. So the detailed study in a parliamentary committee started in February, and it has been going ever since. So the public sector, it's worth noting that as of today, the committee has concluded its study of the public sector portion of the bill and has not yet begun to study the provisions that amend the Private Sector Act. At the federal level, Bill C11 was introduced in November 2020 by the Minister of Innovation, Science and Industry, Navdeep Bains. And unlike Bill 64, which amends existing legislation, Bill C11 completely replaces PIPEDA. So it redrafted the whole bill. So it's a new bill that applies to businesses under federal jurisdiction, as well as in provinces that have not yet enacted their own substantially similar legislation with a new statute. So you have the Consumer Privacy Protection Act, and we'll refer to C11 or CPPA. And this new bill, C11, also creates a new federal administrative tribunal, which we call the Personal Information and Data Protection Tribunal. We also had a federal cabinet shuffle in January, where François-Philippe Champagne succeeded Navdeep Bains as minister responsible for the bill. So as of today, B11 is, I believe, at its second reading and has not yet begun its study in committee. I don't know if some of you saw a couple of days ago, the Privacy Commissioner of Canada published its position paper on C11. Bottom line, he feels that yes, there's some fines that have been added, but he's concerned and he doesn't think that the bill is doing enough to protect privacy. So maybe we can discuss this a little bit. So I've put together on this slide the main changes in the two bills. So the first 2 points are really the ones which we will focus on most of this presentation. So the two bills introduce new notions into law, like de-identified information, anonymized, sensitive information. Both bills provide for certain exceptions to consent, such as allowing the information to be used for research and development, study or statistical purposes, for socially beneficial purposes, or in the course of certain legitimate business activities. So we'll be talking about that. Both drafts introduce new individual rights. So this includes a right to data portability or mobility, as well as a right of disposal. That last right of disposal, is only at the federal level. The two drafts also provide for a new mechanism to ensure organizational compliance with privacy principles. So assessment of privacy-related factor, otherwise known as a privacy impact assessment. There is a privacy by default provision. It also includes certification programs and codes of practice. So both drafts significantly enhance enforcement measures with the introduction of administrative monetary penalties, new order-making powers, the creation of new criminal offenses, onerous penalties, and the recognition of private right of action. So it makes sense to discuss a few important definitions that are relevant when considering doing some research or business analytics using a form of personal information. So first of all, direct identifiers. So this type of information identifies an individual without any additional information, or by easily associating him or her with other information. So personal information, would usually fall into this category. And for example, it could include someone's name, telephone number, unique numbers, social insurance numbers, or employee identification numbers. Sharing direct identifiers creates a very high risk to privacy, as this information can identify a particular or specific individual and can usually be easily used to link other information to that individual. So in the chart of, what kind of information is more sensitive, well, definitely, when you have direct identifiers, it becomes more sensitive. In indirect identifiers, so this information does not directly identify an individual, but once combined with other information, it may single out and therefore identify the individual. So this could include, a date of birth, that we share with other people, postal codes, gender, race, ethnicity. So the maximum number of indirect identifiers that can be included in any data set to preserve the confidentiality of the individuals concerned must be assessed on a case-by-case basis. So you have one expert who recommends that no more than 6 to 8 indirect identifiers should be included in a single data set. Some experts are saying, no, that's too much, maybe a maximum of 3 or 4 in certain areas, in certain fields, definitely. So something to keep in mind. If the data set contains 9 indirect identifiers or more, there is usually a high or very high risk to privacy, as this information can often indirectly identify an individual. So now we have non-identifiable information. In some cases, we see anonymized information. So this information would not allow an individual to be reasonably identified, even if it's combined with other information. So this could include statistics or trends. So this type of data usually creates no privacy-related risk. So I thought it would be interesting to give an example. So personal information, you have someone's name and you have other indirect identifiers linked to that, direct identifier, which is my name. And then if you de-identify this information, then you would replace my name with a code, but all this other information, so all the indirect identifiers would still be linked to that unique number. So it's still relatively sensitive. And then anonymized information would be, you're scrapping any direct identifiers, unique codes, unique numbers, so making this information less sensitive. I just thought we would share this summary because it's interesting to see the approach taken by different bills. So you have the California law, you have the European GDPR, and you have C11 and Bill 64 in Quebec. How are they approaching, anonymized information? Some of them are making a distinction between anonymous, de-identified, and pseudonymous. Some are not. So in some case, it can trigger some challenges. And I know the slides will be shared with you after the presentation. So I just thought it would be a useful slide to share, useful chart. So let's start with looking at the changes relevant for the research sector that are introduced in Bill C11. So the first issue to consider under Bill C11 for the research community is the definition of what constitutes de-identification of personal information. So unlike Bill 64, which makes a clear distinction between de-identified and anonymized information, Bill C11 proposes a flexible definition that appears to incorporate both concepts. So de-identifying personal information means modifying personal information or creating information from personal information by means of technical processes so that the information does not identify an individual. It cannot, under reasonably foreseeable circumstances, be used either alone or in combination with other information to identify an individual. The bill also states that when an organization de-identifies personal information, it shall ensure that the technical and administrative processes used are proportionate to the purpose for which the information is de-identified and the sensitivity of the personal information. So by comparison, personal information within the meaning of the Act is information about an identifiable individual, which implies, according to the federal court jurisprudence case law, that there is a serious possibility that the individual could be identified through the use of that information, either alone or in combination with information from other sources. So in short, when one reads the definition of de-identified information in C11 in light of the definition of personal information, it would seem that de-identified information would not be subject to the law. However, Bill C11 introduces exceptions specifically for de-identified information, making it de facto subject to the law. So moreover, if we consider that de-identified information, according to the definition proposed under C11, is indeed subject to the law, we arrive at a second paradox. So as drafted, this definition can include both truly anonymous information, which under PIPEDA is not considered to be personal information, and also information from which direct identifiers have been removed through pseudonymization or tokenization techniques. Remember that little chart comparing the different laws? Well, under C11, it's all the same thing, so it's potentially problematic. It's also interesting to note that in its fact sheet on the CPPA, the government refers to de-identification as the practice of removing direct identifiers, such as a name, from personal information. So this definition seems to contradict the very definition in Bill C11. So in short, there is significant confusion that needs to be clarified before the bill is passed. Moreover, given that the purpose of Bill C11, which is to encourage innovation, it makes sense to introduce new exceptions to allow certain uses of de-identified information without consent. But it is difficult to understand why Parliament would, in light of this same purpose, subject certain type of information that was not previously covered by the law. I think they need to think about this one a bit more. I think, in my opinion, the federal legislator will have to go back to the drawing board with regard to its definition of de-identification, since it has a significant impact on the scope of the Act. So I hope that we will have the opportunity to discuss the amendments that should be made to C11 to clarify the situation. It should also be noted that Bill C11 remedies a long-standing ambiguity under PIPEDA by clarifying in Section 20 that the act of de-identifying data is to be considered a use of personal information that does not require the consent of individuals. So we kind of knew that it was the case, but it's good to have it in writing in this new bill. Okay, so as previously mentioned, Bill C11 creates certain exceptions where information is de-identified. So according to Section 21 of the CPPA, a company may, without the consent of the individuals concerned, use information that it has collected for a specific purpose for a new purpose, internal research and development. So provided that it has been de-identified. So this exception will allow, for example, the use of de-identified information for business analytics, or as well, we can think of the use for training machines, machine learning algorithms. That could also be another use that they had in mind. It should be mentioned that this exception only concerns the use of the information. So an enterprise cannot collect without consent information for R&D purposes or disclose without consent information for R&D purposes, even if it is de-identified. So two questions arise regarding this exception. So first, what is the scope of the term research and development? If this term is interpreted as it is commonly understood in the industry, it could have the effect of limiting the exception to research activities that involve an element of novelty or originality, such as the development of a new vaccine, which is not always present in statistical research or commercial analysis. So by way of comparison, Bill 64 in Quebec uses the expression purposes of study, research, or the production of statistics, which I like better because it seems to be more encompassing. Second, it is not clear to me what is the relevance of restricting R&D to in-house, internal. So I wonder if this could prevent organizations from invoking this exception when they wish to transfer information to a service provider for the purpose of conducting R&D on their behalf. I presume that was not the intent, so perhaps they should provide some clarification on that notion of internal. The second exception that is relevant for research activities and relates to de-identified information is the one that deals with disclosure of information for socially beneficial purposes. So Section 39 of the CPPA provides that an organization may disclose de-identified information to another specified institution with the consent of the individuals concerned if the disclosure is for a socially beneficial purpose, which the bill broadly defines as any purpose relating to health, the provision or improvement of public services and facilities, the protection of the environment, or any other prescribed purpose. The problem with this exception is that it allows only a unidirectional exchange of information. So a company may share de-identified data with a government institution, healthcare facility, post-secondary educational institution, public library, governmental organization, but there is no reciprocity requirement. The exception, therefore, in my view, fails to recognize the valuable role played by the private sector in pursuing activities which, with socially beneficial purposes. The current pandemic provides a good example, I think, as all of the COVID vaccines being distributed in Canada have been developed by the private sector. So the private sector may have access to talent and resources that could be used to achieve socially beneficial purposes. So in my view, there's no basis that justifies giving the public sector an undue preference or privilege in the pursuit of socially beneficial purposes. So the government has even cited its desire to strengthen public-private partnerships as an objective in support of the new legislation. However, the intention cannot be realized under the current version of Section 39 of the CPPA, given the clear lack of reciprocity, cooperation, or exchange of information between the public and private sectors. Last comment, this section provides no exchange possible between two private sector organizations. Maybe I'm pushing my luck here, but it's something that I would have liked to see in this bill as well. So there are two other exceptions to consent introduced by Bill C11 that are relevant to private sector research, which should be mentioned. So these apply to any type of personal information, so de-identified or not. So first, Section 18 of the CPPA introduces an exception to allow the collection or use of personal information without the consent of the person concerned, when this is done in the context of a legitimate business activity. So this activity must fall within the list provided for in the Act, and you have the whole list there, which you can read. In my view, this exception is good news. I think it will refresh the consent principle, by limiting it to situation where it is actually needed. So I think it's unrealistic these days to expect consumers to take the time to read and especially to understand the numerous and increasingly long and complex privacy policies that they come across when interacting with companies. So I think it makes sense to limit the number of situations where consent is sought and to focus on those situations that really warrant protection. The type of activities covered under this provision include a wide range of business activities. I believe that the inclusion of situation where it is impractical for the organization to obtain consent of the individual due to the absence of a direct relationship with the individual could potentially be relevant in a research context. It will be interesting to see how this criteria will be interpreted by the regulator, since its wording seems to cover a wide range of situations. Some have actually raised some concerns that, perhaps it's too broad. The reference to any other prescribed activity opens the door to the addition of other activities that would be exempt from the requirement to obtain consent. In addition, the activity in question must not run counter to the reasonable expectation of the individual, and the information must not be collected or used for the purpose of influencing the individual's decisions or behavior. So I think the idea behind this last criterion is to avoid any practice that could be associated with consumer manipulation. Obviously we can think of a Cambridge Analytica scandal, but what else did they have in mind? Perhaps targeting of profiling practices. So potentially would not go against research activities. So we'll see. The other relevant exception under C11 is the one introduced by Section 35 of the CPPA, which allows for the disclosure of personal information without the consent of the individual, where there's three requirements, where the disclosure is for statistical, scholarly study or research purposes, and you need that. Consent is impossible to obtain, and the organization informs the commissioner of the communication before it is made. So there's kind of a notification requirement added. So we'll see. We will see that Bill 64 proposes a similar exception, but with more requirements. So you also have to do a PIA, and you have to enter into an agreement. And you have to submit a research protocol. So I'll let Andy talk about these issues in a few minutes. The exception in C11 seems to be more flexible, perhaps even too flexible, since an organization that discloses information without the consent of the individuals concerned and without having ensured that the receiving party will put in place appropriate security measures is exposing itself to risk. One thing that might be of interest with respect to the disclosure of personal information between institutions for research purposes would be to have some sort of template agreement provided by the OPC that would allow organizations to ensure that their sharing disclosure is compliant with the legislation and that appropriate security measures are in place. So this could be a recommendation to be made regarding Section 35 of the CPPA. So Section 55 of the new bill creates a new right for individuals to have their personal information disposed of at the request of an organization. So disposal is defined as the permanent and irreversible deletion of personal information. This right applies only to personal information collected from the individual, which means that an organization will not have to delete information about an individual collected from third parties or information it has inferred about the individual. Where information subject to a disposal request has been transferred by an organization to a service provider, the organization now has an obligation not only to inform the service provider, but it has to obtain written confirmation from such service provider that it has also deleted the information. The reasons for refusing to remove information are limited and have to be detailed by the organization in its written response to the individual requesting disposal. So it's similar, I guess, procedure than when managing an access request. The organization may only refuse a request for disposal if it would result in the deletion of information about another individual, or if federal, provincial, or contractual requirements prevent it from doing so. So the latter exception is likely to be useful to organizations that are subject to retention requirements under applicable Canadian law or under a contract with their customers or business partners. Section 72 of the CPPA creates a limited right to data portability, so which it calls a right to mobility. So this right will allow an individual to request that an organization share his or her personal information with another organization. It designates if both organizations are subject to a data mobility framework. Similar to the right of disposal, the right to mobility will only apply to personal information collected from the individual. So organization will not have to apply this right to information collected from third parties or information derived or inferred from information provided by the individual. Regulations will specify which organization will be subject to mobility frameworks. These are likely to be relevant for specific sectors such as open banking or telecom, where monopolies on data and impediments to its transfer create threats to competition, or where interoperability is essential to services being provided. So quickly, on this slide, you have a few suggestions for amendments to Bill 60, to Bill C11 to facilitate data sharing for research purposes. So exclude anonymized information from the scope of the Act, reiterate the principle under PIPEDA that anonymization is equivalent to the destruction of personal information, removing the term internal from Section 21, revising the scope of Section 39 so that it can apply to the disclosure of personal information for socially beneficial purposes to private organization, or even better, between two private sector organizations. That's on my wish list. Adding to Section 35 a requirement to enter into a disclosure or sharing agreement and require that the regulator issue a template, thereby reducing the legal risk for organizations that may share personal information for research purposes. I will now turn the floor over to Andy, who will present the relevant changes in terms of business research that are introduced by Bill 64 in Quebec.
So thank you, Eloise. So as Eloise mentioned at the beginning of the presentation, Bill 64 is moving through the legislative process more quickly than its federal counterpart. The study of the bill in parliamentary committee began in February, which means that there are already a few amendments that have been adopted to modify the bill. However, as Bill 64 is structured in a manner that begins by amending the Public Sector Act, which is really the law that applicable to public bodies in the province, The amendments adopted so far do not affect the private sector directly. That said, considering the fact that Bill 64 makes many of the same amendments to both acts, it is possible, but perhaps not guaranteed, that the amendments adopted in the public sector will also eventually be reflected in the private one as well. So for next slide. So turning to the new concepts introduced by Bill 64. So there are three new concepts, or more specifically, types of information that are introduced in the private sector and in the public sector as well. The first one is de-identified information, which is defined as information that no longer directly identifies a particular individual. So this clearly refers to personal information from which direct identifiers, which we discussed earlier, such as an individual's name or social insurance number, have been removed, but which retains a certain number of indirect identifiers, for instance, age, gender, ethnicity, and so on. In this sense, de-identification is similar to the concept of pseudonymization, which essentially means that information is still technically identifiable, but only indirectly. Although de-identified information is still subject to the entire scope of the legislation, it benefits from certain consent exceptions, which we will discuss a little bit later in my presentation. It is pertinent to know that at this point that an amendment was adopted in the Public Sector Act, which specifies that an organization that de-identifies personal information must take reasonable steps to limit the risk of re-identification. We've seen that there is a similar provision under Bill C-11, which calls for proportionality in terms of the technical and organizational measures that are applied to de-identified information. Under Bill 64, there would be a duty of care, which will require an organization to take certain steps to ensure that de-identified information is not retained, used, disclosed in a way that would allow it to be re-identified. The other new concept introduced is that of anonymized information. In other words, information that irreversibly no longer allows the person to be identified directly or indirectly. The bill specifies that when an organization anonymizes information, it must do so in accordance with generally accepted best practices. In contrast to Bill C-11, Bill 64 expressly excludes anonymized information from the scope of the Private Sector Act, since it treats anonymization as a form of destruction of personal information. This recognition that anonymized information is no longer subject to the Private Sector Act is a welcome addition because it avoids the ambiguity that currently exists under the Bill C-11. That said, it is not entirely clear whether or what standard of anonymization will be required in any given situation. We know that achieving true anonymization is very demanding, and many have even expressed doubt as to its feasibility, especially given that it may not be possible to eliminate the risk of re-identification entirely. This will likely require organizations to periodically reevaluate the risk of re-identification and consider whether there have been any major developments regarding generally accepted best practices in the field of anonymization. It's interesting to note that an example of this approach can be found under the European Union's General Data Protection Regulation, so the GDPR, which calls for a risk-based approach to anonymization that considers all objective factors, such as costs and the amount of time required for re-identification, and taking into consideration the available technology at the time of the processing of the information and technological developments. Now, turning to the third new definition, it concerns the notion of sensitive personal information. So Bill 64 specifies that personal information will be considered sensitive when, due to its nature or by the context of its use or disclosure, it gives rise to a high reasonable expectation of privacy. What you see in red on the slide is an amendment that was passed under the Public Sector Act, under the equivalent definition that's found under the Public Sector Act, and that will most likely find its way in the Private Sector Act as well. So the main benefit of this definition is that it is inherently contextual, so it avoids creating an overly prescriptive, exhaustive list of particular types of information that are de facto considered sensitive, which is the current approach under the GDPR, for instance. This means that under Bill 64, the sensitivity of personal information is intrinsically linked to the context of its use. However, the amendment in red changes somewhat the flexible nature of the definition, as medical, biometric, or otherwise intimate data are now considered sensitive by nature. In other words, independently of the context in which this information is being used. This raises the questions about what will be considered, for example, biometric, as this term is not expressly defined and may have broader implications for certain technologies that collect information about an individual's physical, behavioral, or biological traits. Similarly, it is unclear what will be included under the term otherwise intimate information, as almost essentially any information could qualify as being intimate depending on whose perspective is taken. In practical terms, the main consequence of the qualification of information as being sensitive under Bill 64 is that an organization is required to obtain express consent before using this personal information. An exception to this requirement is if sensitive information is de-identified beforehand, in which case it is likely to lose its status as being sensitive. So now turning into to discuss a few new exceptions that are introduced under Bill 64. With respect to secondary use of personal information, Bill 64, similar to Bill C-11, provides that personal information initially collected for specific purposes may be used without consent for study or research purposes or for the production of statistics, like it is mentioned earlier, provided this information is sufficiently de-identified beforehand. It is important to note that the terms used under Bill 64 are different from those under Bill C-11. So as it is mentioned, the exception under Bill C-11 is limited to internal research and development purposes. In contrast, Bill 64 appears to be somewhat broader as it includes the production of statistics and is not limited to internal purposes. Despite this difference in terminology, it is generally safe to say that these two exceptions share the same ultimate objective, which is to enhance opportunities for organizations to use previously collected information in new and innovative ways, provided this information has been sufficiently de-identified. This is an example of how data protection laws seek to strike a balance between an organization's legitimate need to collect, use, or disclose personal information and an individual's right to privacy. It is nevertheless important to note that this exception, like under Bill C-11, only applies to the use of de-identified information. In other words, this does not authorize an organization to collect or disclose this information without consent. Bill 64 also provides that personal information may be used for other purposes without consent if these purposes are consistent with those for which the information was initially collected. In order to be considered consistent with the initial purpose, the secondary purpose must have a direct and relevant connection. Unfortunately, what constitutes a direct and relevant connection is not expressly defined under the legislation, but we suspect that this will depend on a variety of factors, including the relationship between the parties. In passing, we should note that this notion of consistent purpose has existed under the Public Sector Act since 2006, but has received very little interpretation. The third and final situation in which personal information may be used for secondary purposes without consent is when the intended use is clearly for the benefit of the person concerned. Here again, this exception is already found under the Public Sector Act, but there is unfortunately very little case law interpreting its scope. However, the broad wording of this exception suggests that it could potentially apply to a number of different situations. It's important to note that unlike Bill C-11, Bill 64 does not provide an exception for legitimate business practices. This potential gap may be somewhat remedied by these other consent exceptions, as some of these business practices could arguably qualify as either a consistent purpose or as a purpose that is clearly for the benefit of the individual concerned. For instance, this could include the use of personal information in order to provide a service requested by the individual, or even ensuring the safety of a particular product or service.
I think that perhaps they will be proposing an exception. I think that this is coming in their discussion, so something to keep on our radar. Okay, so next slide. Sorry about that. Okay.
So another welcome change under Bill 64 is the fact that it reforms the process for disclosing personal information for study, research, or statistical purposes without consent in both the private and public sectors. In particular, Bill 64 eliminates the need to obtain prior authorization from the Quebec privacy regulator in these circumstances, and it therefore replaces the current regime, which is found under sections 125 of the Public Sector Act and section 21 of the Private Sector Act, with a three-step process that you can see on screen. So just to go through these quickly, step one, the organization or body wishing to receive the personal information must make a written request to the disclosing organization in which it outlines its research protocol and describes the reason justifying the disclosure of personal information, having regard to certain prescribed factors. It must also describe the different technologies that will be used to process the information, and if applicable, provide the decision from an ethics committee regarding the research in question. Turning to step two, the organization or body receiving the request must then also conduct what amounts essentially to a privacy impact assessment. And through this assessment, the organization must determine if certain requirements have been met. This includes determining whether the objective of the study or research can be achieved only if the information is communicated in a form allowing the individuals concerned to be identified. Other factors that must be considered include whether it is unreasonable to obtain consent in the circumstances, whether the objective of the research outweighs the impact of the privacy of the individuals, whether personal information is used in a way that ensures confidentiality, and whether only the necessary information is being communicated. Once you make it through step two, step three requires the parties to enter into what amounts to a disclosure agreement containing several prescribed elements, which are expressly listed in the legislation itself. So this includes, for instance, provisions limiting access to information on a need-to-know basis and requiring those with access to have those who have access internally to have signed a confidentiality undertaking. Other provisions include restricting the use of the information to the purpose of the research, prohibiting the communication of publication or dissemination of the information in a form that identifies the persons concerned, indicating the measures that will have to be taken to ensure the protection of the information, as well as the period of time for which the information will be retained, and finally, providing for an obligation to notify the disclosing organization and the Quebec privacy regulator in the event of a breach of the agreement or any event that may otherwise affect the confidentiality of the information. So it is also important to note that this agreement must then be sent to the Quebec privacy regulator and that it comes into effect 30 days after its receipt. In other words, it is on that date that the organization is permitted to disclose the information. So there are essentially three takeaways here with respect to the new research exception. First, even though the requirement to obtain express authorization from the Quebec privacy regulator has been removed, this exception remains much more onerous in Quebec than under the federal regime, which it is discussed earlier. Another key takeaway is the fact that Bill 64 limits this exception to information that is necessary for the purpose of the research. However, this necessity criterion is difficult to reconcile sometimes with certain types of research projects, such as those involving artificial intelligence and machine learning, where a large volume of data is required in order to train algorithms and identify relevant statistical correlations. In other words, it may not always be clear at the outset of a research project what data will be necessary in order to achieve a particular outcome. A more flexible notion would be better suited in this context. Similarly, the requirement for the receiving organization to describe the technologies that will be used to process the information may also impose an undue limitation on innovation and research. given the pace at which technologies are developing, it would be counterproductive for researchers to have to go through this three-step process that I mentioned every time they want to use a new type of technology to process information. Finally, it is questionable whether it is necessary to set out within the Act itself the detailed content of the research disclosure agreement. It would be preferable to have this set out in a regulation, as this would be easier to amend and adapt over time. So now turning to certain notable issues under Bill 64, the bill introduces a general obligation to conduct APIAs, which the bill refers to as an assessment of the privacy-related factors for any proposed information system or electronic service delivery that involves some form of processing of personal information. This is a very broad obligation, which is likely to apply to a wide range of data processing systems. However, the government seemingly intends to narrow the scope of this requirement, as an amendment was passed recently under the Public Sector Act, which clarifies that this requirement only applies to the acquisition, development, or redesign of these systems. In other words, there would not be an obligation to conduct APIA with respect to existing systems at the time the Act comes into force. It is also helpful to note that this amendment clarifies that the PIA must be proportionate to the sensitivity of the information concerned, the purpose of its use, as well as the amount, distribution, and format of the information. This essentially provides greater flexibility for organizations regarding the level of detail required by a PIA. With respect to data portability, Bill 64's scope is somewhat broader. Unlike Bill C11, which is really limited to request the transfer or mobility of data between organizations. So, for instance, between organization X to organization Y, Bill 64 also allows individuals to request to receive their personal information themselves in a structured and commonly used technological format. Bill 64 also states that organizations should take this requirement into account in the design of their systems. However, as under Bill C11, inferred information about individuals, in other words, information that hasn't been directly provided by the individual, does not appear to be covered by the data portability requirements. So now I will hand it over to Eloise, who will say a few words about the new requirements for transfers of personal information outside Quebec.
Yes, thank you, Andy. So it's relevant to note that an amendment was adopted on March 24th to modify Section 70.1 of the Public Sector Act under Bill 64. So we're just suspecting that a similar amendment could be made to the private sector portion of the bill. We know that the issue of cross-border transfers was the subject of several comments during the public consultation on Bill 64. So the government wanted to rectify this in its bill. We again likely will be included in the private sector. So as you can see from this slide, the proposed changes are in red. So it's a little bit better, but there's still a form of assessment of the foreign law, which could be problematic. So hopefully they will get it right when they do the study of the private sector portion of Bill 64. I will hand it over to Andy to conclude on Bill 64.
So thank you, Eloise. So although there are a number of positive changes under Bill 64, there are also opportunities to improve and amend the bill in order to further facilitate data sharing between organizations for legitimate purposes and to promote research and innovation. To this end, we have prepared the following suggestions for amendments that could be made to Bill 64, or at least we hope to see in future amendments. The first one, we would recommend introducing a more overt risk-based approach to anonymization of personal information, similar to maybe what we've seen under the GDPR, in order to enhance opportunities for organizations to use information that presents a low risk in terms of privacy. Another suggestion would be to make the process of disclosing personal information for scientific research purposes more flexible, by, for instance, creating exceptions for the disclosure of de-identified information. This could be similar to the socially beneficial purposes exception found under Bill C-11. Other suggestions could include replacing the necessity criterion, which I previously mentioned, with a more flexible notion, for instance, that of relevance, and also removing the requirement to describe the technologies that will be used by the receiving organization, or including the nature, scope, and content of disclosure agreements in a regulation rather than in the legislation itself, as I previously mentioned. Finally, another important change would be to ensure that the requirements for transfers of personal information outside Quebec are not too restrictive. The requirement to conduct a PIA before making a transfer is not necessarily a bad idea, as it enhances accountability, but we question whether it is necessary or even feasible to assess the legal regime of the jurisdiction to which information will be sent, especially when contractual protections are already required. So in terms of what we can expect next, so what we can expect moving forward, there is a general divergence that we've talked about between the federal and provincial governments regarding the enactment of these bills. In Quebec, Bill 64 is progressing at a fairly rapid pace, despite the fact that at the federal level, Bill C-11 is moving at a much slower one. This unfortunately raises concerns about a potential lack of harmonization between the two bills. However, the Quebec government has not commented on a hard deadline for the adoption of Bill 64. But there are indications at the very least that it will probably not be adopted by the end of the current legislative session, which is scheduled to end in June. This essentially means that the enactment of the bill in Quebec will have to take place in fall 2021 at the earliest. As for the coming into force of the provisions of Bill 64, it is currently set at 1 year after the bill's assent, which, assuming that the bill is adopted this year, brings us to the end of 2022 or the beginning of 2023. The only exception to this is the right to data portability, which would enter into force 3 years after the bill's assent. In contrast, the situation at the federal level is less clear. The second reading of the bill began on March 26th. It is therefore reasonable to expect that the bill will be sent to committee in the near future. It is at this stage that we can expect to see some form of public consultations take place. Of course, there's always the risk that an election will be called, which could also put in jeopardy the enactment of Bill C-11. It should also be noted that Bill C-11 does not specify what the transition period would be if passed, but based on the transition period for similar initiatives in other jurisdictions, for instance, GDPR in Europe or the CCPA in California, it is likely to be anywhere between 1 to 2 years after it is enacted. So now we're at the Q&A portion of the presentation, and I'll turn it over to Eloise.
Sure. So we will take some questions. The only thing is I see that we only have 7 minutes left, and we had a lot of questions to answer, but we'll get going. Maybe we'll answer some of them more quickly. So one question that we had was, what are the consequences if a company uses data for research purposes but has not sufficiently de-identified the data within the meaning of applicable legislation? So, well, in that case, the company would be in contravention of applicable law, federal or provincial, which would now bring into play potential penalties for non-compliance. Maybe I can speak for Bill C-11, and Andy, you can speak for Bill 64. So under Bill C-11, a contravention of the Act can be the subject of a complaint to the OPC, which would then conduct an investigation. At the end of the investigation, the OPC can issue a compliance order. And in certain circumstances, it can also recommend that the new tribunal that would be created, impose a monetary penalty on the company. So use for a new purpose without the consent of individuals can be subject to a penalty under Section 93 1B. So it's not a risk to be taken lightly. The maximum penalty is 3% of gross global revenues in the preceding year, or 10 million. So maybe Andy can cover Bill 64.
Yeah, so unlike Bill C-11, which really provides for specific contraventions that give rise to the imposition of penalties, Bill 64's equivalent provisions are much broader. In particular, it states that, for instance, any person who collects, discloses, uses, or destroys personal information in contravention of the provisions of the Act may be subject to an administrative monetary penalty, which is imposed by the Quebec privacy regulator. After giving the business an opportunity to make representations. The maximum administrative penalty is $10 million in Quebec, or 2% of the organization's worldwide turnover in the preceding fiscal year.
Okay, so we have one question that we have to take because it deals with data trusts, and I think it's important to talk about that. So the question is, we've been hearing a lot about this concept of data trust, but what does this mean in practice? And how does this fit within the proposed reforms? Andy, do you want to take this one?
Sure, yeah. So essentially the concept of a data trust is often mentioned in the context of research and public-private partnerships. And the idea is to essentially create a trusted intermediary that holds and manages individuals' personal information on their behalf. This includes managing when, where, how third-party organizations and public sector entities may access and use this information, and subject to what conditions. In theory, this centralized form of data governance would enable individuals to exercise greater control over their information and enhance security. For organizations, the main advantage of this scheme is that they can access personal information and use it for a particular purpose without having to obtain consent directly from each individual. From this perspective, data trusts share some of the key attributes associated with traditional trusts, which are managed by trustees on behalf of beneficiaries. While there's still an ongoing debate about whether personal information can truly be held in trust in the manner contemplated under Quebec civil law or under Canadian common law, the underlying intent is to have a central figure with fiduciary-like obligations manage personal information for a particular purpose and be accountable towards individuals whose information is concerned. Although the federal government has expressed interest in this topic, Bill C-11 does not expressly refer to the concept of data trust. That said, the socially beneficial purposes consent exception may be seen as a step towards recognizing this form of data governance. In contrast, in Quebec, the government has not really been as overt in discussing this concept or how it should be integrated under Bill 64. While there are perhaps broader, mostly academic debates about this, it is unclear whether this concept will find the same foothold in the Quebec.
Okay, thank you. We had one question about whether the Privacy Act is currently being modernized. What are the trends that you may expect to be included in the new Privacy Act legislation? And did you want to answer this one?
Sure. Yeah. So essentially, well, we expect to see a lot of the similar changes introduced under the Federal Privacy Act, such as consent exceptions for the collection, use, and disclosure of de-identified information for socially beneficial purposes, which really mentions public sector entities, and also exceptions for research and development activities. So, whether it goes further than Bill C-11, that's the real question, and it remains to be seen whether it's going to be more flexible and broader in scope.
One question about what do these legislative reforms mean for nonprofits? The short answer is there's no changes. Basically, under both bills, it doesn't change. Like the notion of commercial activities and all this stuff doesn't change. So there's no impact. Maybe I can take a last one. So some about okay, so I have one which says, what is the practical impact of the federal exception for the use of de-identified information for research and development purposes if a company has already obtained consumer consent through its privacy policy to process their data for business analytics purposes? In short, what more does it allow that we can, does it allow that we can't already do? Interesting. So obtaining consent for privacy policy has its limits. Many companies mention this type of use in their privacy policy, but keep in mind that normally any secondary use requires optional consent. So opt-in or opt-out depending on the sensitivity of the information and the context. So there may be some ambiguity about analytics related uses. You know, is it really a secondary use? In some cases, perhaps it's not. It should also be noted that a reference to secondary purpose in a privacy policy does not circumvent the necessity principle of collection, right? So a company cannot collect information that is not necessary for the initial purpose, you know, providing the service. If it actually wants to use this information for a secondary purpose, you know, analytics. The exception introduced by C11 limits the legal risk for research because it allows a company to use without consent the data it already has for research and development purposes. So yes, to some extent, the company may have obtained specific consent to use the data for analytics or potentially through the policy, but it is likely that there is a good deal of data that was not collected in this way at all, or was indirectly or without mention in the policy or without consent, in which case it is now possible to use it for analytics. So it still opens a few doors in my view. So I think that's all the time we have. So I think this concludes our presentation. So thank you very much for attending. And please don't hesitate to reach out to us if you have any further questions. So have a nice day.
Thank you.